Civic Scholars, I'm back. You're back. It is either Thursday or Friday, and we are off to getting going again as we approach the weekend. Again, I'm not here, obviously, in the classroom, but I'm here on the screen. So follow along closely. Hopefully, you've already watched CNN 10 and gotten up to date on what's going on in our world today. Now, please go ahead and turn in your Second Amendment work that dealt with the Heller case, and then as well as the free right. If you can get those things turned in right now as I'm talking, that'd be great. I'll be able to see when those got turned in when I go back and grade those and give you credit if you got those done in and on time. Today, we're going to transition into the Fourth Amendment. We're skipping over the Third Amendment because I don't think that many of you or any of you have ever had a soldier show up to your door and tell you that you have to give them a place to basically live and feed them. That dealt with the Third Amendment, that our government and our military is not allowed to do that. So we're just going to skip over that one because that's not terribly relevant in our world today. But the Fourth Amendment it deals with search and seizure. Is the government allowed to go through your stuff? And if they are, when can they do that? Whether that's your backpack at school, whether that's your car, whether that's your house, whatever your possession is. And this even gets into, are they allowed to, like, your body is part of your property. Are they allowed to test for drugs or test for alcohol use or stuff like that? So that all deals with privacy and search and seizure. So that's what the Fourth Amendment is dealing with. And so that's what we're going to be covering today. And then we'll obviously talk more about it next week on Monday or Tuesday. So now that you've turned that in, I'm going to, or the sub can go ahead and stop this video in a second here. And you're going to watch a quick clip called Search and Seizure Crash Course Government and Politics video clip. And it's right up here in the top of the screen. Let me see here. It's right here, so hopefully this gets stopped, I get stopped, and you can start watching. Okay, we're back. Yeah, the Fourth Amendment, got a lot of stuff in there, some controversial stuff, and when and where can the government look through your stuff? Your stuff, again, being whether it's your backpack, your purse, your person, your car, your house, your apartment, your property, whatever. Because they're allowed to, but you want to make sure that they are doing it in the right way. So your assignment, or what we're going to be doing next, is going through this Fourth Amendment search and seizure in schools PowerPoint. You should have the note sheet up. You can pop it open in classwork. I'm going to put it up on my screen here. And we're all going to go through that together. So these are some more notes you can take, and you don't have to take them. They're not due. They're not assigned. But to practice your note-taking skills, you might want to follow along and fill in those blank note sheets as we go. I'm not going to go terribly slow because you can go ahead and go back and look at this PowerPoint if you need to fill some stuff in. And remember, these notes could help you when you're studying for the final assessment for this class in a couple, or for this unit in a couple of weeks, or in case we were to have some open note, open homework quiz, you'd be able to use these on it. Okay, so Fourth Amendment searches and at school. Because first of all, what is the Fourth Amendment? The Fourth Amendment protects a person's reasonable expectations of privacy. Reasonable expectations of privacy. That's kind of like what does that mean? And that's why we have our court system, so that they can help decide and interpret what laws say and mean. The Fourth Amendment of the United States Constitution prohibits unreasonable searches and seizures of persons or property. So really what it says is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So really, up here, all these things can't be searched by the government unless, or these things can't be violated, your privacy to those things, unless they have some sort of warrant, which needs to show that there's probable cause that a criminal activity had taken place or was taking place. And then it says supported by oath or affirmation. So they've got to have some evidence there. And it's got to be describing, I'm going to move myself. There we go. And it's got to be describing like where it can be searched and what exactly needs to be being searched for. So what is a reasonable expectations of privacy? Here's basically what it says. And a very famous Supreme Court case talks about what the expectations are in Katz versus the United States. We're not going to go through all that stuff there. But, hey, where do you think people can reasonably expect privacy and why? Well, in your home, your yard, a friend's house, shopping, work or school, public park, jail. Like where does there need to be privacy? And then what kinds of things can people reasonably expect to have privacy in? Again, why and why? Houses, cars, computers, emails, luggage, purses, backpacks, phone conversations. And now we get into cell phones, handwriting, photo, voice samples. Okay, so in general, there's this like continuum of certainty going from like not certain at all, like, and then this continuum to like 100% positive that something happened. So in general, to conduct a search, a government official, remember that could be like a school employee, like we're government officials, or a police officer is a government official, must establish probable cause to believe that a crime has been committed and must obtain a warrant. So what does probable cause mean? This kind of continuum. At one end, like it says here, there's zero or no information that something happened. The next, maybe you move over a little bit on the continuum, is that someone has like a hunch, like they think something might have happened. Have you ever heard someone say, "I've got a hunch"? It means they have an idea, not a lot of proof, but they have an idea that something was going on. Next would be reasonable suspicion, and under whatever the circumstances are. So that's kind of next along that continuum. So yeah, we got a little more than a hunch. We're starting to see some things, and some things are starting to add up that some sort of criminal activity has taken place. Next, there's probable cause, which is a little more evidence and a little more certainty that a criminal activity has taken place. That's what the government has to have in order to obtain a search warrant, in order to search through your stuff. So if there's 51% and above evidence or proof that something criminal has happened, that's what we call preponderance of evidence. And then like 80% to 100% that something is going down, something wrong happened, a criminal activity happened or took place. That's what we say beyond a reasonable doubt. So under the Fourth Amendment, the government has to have, or has to be able to prove, probable cause, which amounts to more than having just a suspicion, but less than evidence that would justify a conviction or someone be found guilty. So here's where it starts to affect you guys. It's different what can be searched and seized or taken in a public school. Remember, I always go with public schools for sure, because they're government funded, as opposed to if you get pulled over on the side of the road and what evidence or proof that the cops need to have to go searching through your car. All right. So remember that Tinker in Des Moines case? It talked about with the black armbands. The ruling was like schools have the right to go through stuff basically, because or can limit the rights of students at schools, because what they said, students do not shed their constitutional rights at the schoolhouse gate. So there they upheld, like, you don't totally get rid of your rights. You don't shed them. You do keep some of them. So the Fourth Amendment's prohibition or stopping of the prohibition on unreasonable searches and seizures applies to searches conducted by public school officials. How should public school officials strike a balance between protecting a student's legitimate expectations of privacy and the school's legitimate need to maintain a safe environment in which learning can take place. So there is less certainty required for school searches. In a school setting, teachers or other school officials are not required to establish that probable cause or to even obtain a search warrant for a search to be constitutional or legal under the Fourth Amendment. And some things that have been written or said: requiring a teacher to obtain a warrant before searching a child suspected of an infraction of school rules or of the criminal law would unduly interfere with the maintenance of the swift and informal disciplinary procedures needed in the schools. Basically saying schools need to be able to act quickly to maintain safety in schools, and they don't have the time to obtain a warrant. In order to obtain a warrant, the police need to go, basically first they got to have some evidence that something happened. Then they need to go to a court and go to a judge and present their evidence as to why they need a warrant. Then it takes time for that judge to give them the warrant, and then they can go do their thing. The schools don't have that time, they would argue, in case they need to take care of something quickly to continue to have a safe learning environment at schools. So that next bullet point down, the accommodation of the privacy interests of school children with the substantial need of teachers and administrators for freedom to maintain order in the schools does not require strict adherence to the requirement that searches be based on probable cause to believe that the subject of the search has violated or is violating the law. Rather, the legality of a search of a student should depend simply on the reasonableness under all the circumstances of the search. So school officials don't need probable cause, they need reasonable suspicion. A public school official, like it says here, must have reasonable suspicion to justify a search of a student. So at schools, school administration or workers at a school, they don't need what the police need to search through stuff. They can do things with a little less evidence, a little more freedom. So what is a reasonable school search? It says determining the reasonableness of any search involves a two-step inquiry. So first of all, one must consider whether the action was justified at its inception or whenever it started. Second, one must determine whether the search as conducted was reasonably related in scope to the circumstances which justified the interference in the first place. A search of a student by a public school official will be justified or it's okay at its inception, at its start, when there are reasonable grounds for suspecting that the search will turn up evidence that the student has violated or is violating either the law or the rules of the school. Further, a search will be permissible in its scope when the measures adopted are reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. These were all things put in the ruling in the Supreme Court, New Jersey versus TLO in 1985. So basically what happened in New Jersey versus TLO, which kind of set a precedent or some standards for when and what school officials can look through at schools, was a high school student was caught smoking in the bathroom and the assistant vice principal searched the student's purse for cigarettes. When the search turned up rolling papers, marijuana, and a list of people who, like the list had on it, people who owe me money, the student claimed that the search of her purse was unconstitutional under the Fourth Amendment. And she sued the school, and it went all the way up to the Supreme Court, where the Supreme Court ruled with the school. They basically said they had such and such evidence, and in order to keep school safe, she had broken some rules, so they were allowed to, just by the the assistant vice principal, seeing that there was kind of some smoke in the bathroom, the girl that was in there, they just with the smoke being there, they were able to go through her backpack, and then they found that other stuff, which got her into even more trouble. So if so, was the search reasonable in scope under the circumstances? Here's another one. In a court case called Safford Unified School District number 1 versus Reading. This is a much more recent case, 2009. So most of you were alive when this happened. A middle school student, Savannah Redding, was suspected of distributing over-the-counter and prescription pain relievers to other students based on a tip by another student. School officials conducted a strip search of Savannah and did not find any pills. Savannah's mother sued the school district for violating her daughter's Fourth Amendment right to be free from unreasonable searches and seizures. It mentioned in that last video that we watched, I hope you were able to watch just a few minutes ago, where there have been some Fourth Amendment violations. And there's this thing that we have called the exclusionary rule. We have it in the United States, but there aren't a lot of countries around the world that still have this. And it's a key term. It's something we want to know. And this was sort of established, this exclusionary rule, back in a 1961 court case called Mapp versus Ohio. Again, it was talked about in that video that you just watched. Evidence obtained through a violation of the Fourth Amendment is generally not admissible by the prosecution during the defendant's criminal trial. So if there's evidence found illegally, if the government searches and seizes some stuff and don't do it the right way or don't follow the law, even though there might have been some illegal stuff found or some evidence that there were some criminal activities, the government cannot use that in court to try to find someone guilty of a crime. So rationale is that if police know evidence obtained in violation of the Fourth Amendment cannot be used to convict someone of crime, they won't violate it. So police officers know that if they go into your house without a warrant and find some illegal stuff, it's going to stop them from even going into your house. They're going to go get a warrant from a judge to make sure they're doing things the right way. The consent search. Because Andrew gave the officer permission to look in his wallet, Andrew cannot later claim that the officers violated his privacy rights. So if you give consent, the cops pull you over and say, can we look through your car? And you say yes, then they can look through your car. They can look in your trunk, they can look in your glove compartment, they can look all over the place because you gave consent. That's not an illegal search then. Again, unless the officer coerced or kind of tricked Andrew into giving consent, such as using threats or force, the search is perfectly legal, even if the officer had no reason to suspect that Andrew had committed any crime. How about drug testing for athletes? Because your body is considered your property, and you're supposed to have privacy rights to whatever property you have. And so some people felt like giving, especially high school athletes, drug tests without their consent should be illegal. In 1995, the United States Supreme Court ruled that public school athletes can be required to undergo drug testing, even if they are not suspected of using drugs. So our school, if they wanted to, they could test all athletes, even if they don't have a hunch that they're using any drugs. Justice Scalia, at the time, he's now passed away, gave several reasons for testing student athletes before anyone else in the student body. Because some people would say, well, why can you just test athletes? Don't you have to test everybody? That's unfair. That's picking out a certain group of people and treating them differently. The argument there was that no, student athletes have lesser privacy expectations because they're accustomed to dressing and showering in locker rooms. That was part of his opinion. Second, he wrote, they have to get physicals, keep a minimum GPA, and comply with rules of the team. Other students don't necessarily have to do that. So what's the difference between having them do a drug test? His third thing was student athletes are role models to other students and should be held to a higher standard in a sense. And then lastly, he says that there are some drugs that make athletes maybe better athletes, but are unhealthy to their body. So we might be doing this, or we're going to allow for this to try to help out kids not be using steroids and illegal drugs because that could harm their body. So there's where we're at with some of those things with drug testing and in schools and search and seizures in schools. So even though in that Tinker case with the armbands, the Supreme Court ruled that you don't necessarily get rid of your First Amendment in that case, or just any amendments, liberties and rights at a school, this shows us that other times you do. School officials don't necessarily need the same evidence or even like a warrant to go through your stuff at school. They need very much less ideas or evidence that criminal activity is taking place, as opposed to what police officers might be able to do once you're off school grounds. Okay, now you're taking those notes. You're going to need to go into Google Classroom, and you've got, again, the rest of the block here, which should be plenty of time to get your work done. If you get your work done, again, you've got free time, find reasonable educational entertainment, and that might be getting your work done from the previous class if you didn't get that done. So really, after today, you should have at least your stuff from Tuesday or Wednesday done, and then hopefully your stuff from today or Friday done, depending on which day you are. Okay, this handout. Handout 1, the Fourth Amendment, has a couple things in here. And first of all, here's the Fourth Amendment in its original form. Then it kind of explains what it means here. You need to use those 2 paragraphs there and answer these couple of questions. Then you get down to handout 2, exceptions to the warrant requirement. So there are some exceptions to when a police officer doesn't have to have a warrant to look through your stuff. And there are 1, 2, 3, 4, 5, 6, 7 different exceptions. Again, those are 7 different times that the police or the government does not need a warrant to go through your stuff. On here then, on handout 3, it says applying the exceptions. There are 1, 2, 3, 4, 5, 6, 7 different scenarios that they play out. So the first one, just for example, at the local shopping mall, an undercover detective notices a group of teenagers shopping together. Following them, he observes no illegal behavior. However, once they exit the mall, he stops them and orders them to turn over their purses, wallets, and jackets. You then need to take that scenario and fill in the first box. Is the warrantless search legal? Yes or no? Then the next box over. If it's legal, list and explain the rule that applies from handout 2. So which exception would that police officer be able to say they used in order to do that? So you got to do those for all 7 scenarios there. Make sure you're full and complete with your answers, and then you can explain yourself. All right. Then lastly, let me open it up here. In Google Classroom. Whoa. In the wrong spot. There's one other assignment for you to be working on. Sorry, I should have this pulled up. And it is this Fourth Amendment scenarios worksheet. And there are 10 different scenarios you need to read through and then decide whether the search, again, violates the Fourth Amendment and whether the evidence seized can be used in court. So like number 1, the police see Dell standing at a bus stop on a downtown street in an area where there is extensive drug dealing. They stop and search him and find drugs in his pocket. A, did the search violate the Fourth Amendment? B, can the evidence seized be used in the court? Explain. It's basically asking you 2 things. Did it violate? And if so, or if not, still can that evidence that they found be used against this person in a court system? And you got to explain that stuff. So use complete sentences, not just yes or no answers, to complete this. So once you've got those 2 things done, like I said, you've got free time. You need to be working on both of those individually at your seat. If you want to pop in some music, go ahead and get that going. Otherwise, make sure you're using your time wisely, and then hopefully you don't have any work for civics over the weekend. Okay, I should have access to my phone a little bit where I can check my email. So if you do have questions, please feel free to reach out. Let me know, and I'll try to get back to you as soon as possible. Otherwise, have a great weekend, and I will see you all on Monday or Tuesday.